Well, good morning, everybody. Welcome to the third installment of the Construction Risk Series presented by Kenny and Sams. My name is Drew Colby. I'm a construction lawyer and I've been a construction lawyer for over 35 years. My practice is comprised of half transactional, which means I negotiate and draft construction contracts. And the other half is dealing with payment and performance issues, dispute resolution, litigation, arbitration, et cetera, et cetera, et cetera. I'm presenting today with Anthony. Anthony, if you could identify yourself, please.
Good morning. I'm Anthony Duffon II. I'm an attorney with 11 years experience, where really the last 7 years have been focused on design and construction defect litigation. Here at Kenny and Sams, I serve as risk management and litigation counsel to contractors and design professionals throughout the country.
So, as I said, this is part of a series. The first series that we had talked about price escalations, particularly in light of the lumber, escalation and then somewhat of a collapse. Probably not as much of a collapse as people would like. Um, our first discussion was on price escalation. Our second discussion was on employment best practices. Today, we're going to be talking about residential renovation projects, and our next installation will be on insurance, key terms of insurance, because we all know how important insurance is. Um, if at any time you have any questions or issues that you want to address, please just put them in the comments section. And if we have time, we'll get to them today. If we don't have time, or if you'd prefer to email or telephone us, please do so. We'll get to everything as best as we can. So, what is this home improvement contractor statute? Anthony, why don't you lead it off and tell us all about it?
Sure. Thanks, Drew. First and foremost, it's an incredibly significant statute that contractors must be aware of. When it was first enacted, this law was designed to protect homeowners from unscrupulous or dishonest contractors. But how we see this actually played out is where it serves as now as a gateway actually to exposure against contractors from homeowners. So what we're trying to do is we're trying to serve, I guess we want to call it preventative medicine, or a mechanism in which we can prevent the harm or the liability from actually happening.
So, roughly 10, 15, 20 years ago, uh, the courts began to see that there was a lot of home improvement contractor cases that were brought. And the legislatures got wind of this and said, we've got to do something about this to kind of even this playing field. We're just seeing way too many of these things. And then one by one, these statutes began cropping up in the different states that said, okay, let's put together some sort of statutory framework that everyone has to follow. And maybe this will help to reduce some of these claims. And so one by one, the states started doing it. Mass was an early adopter of the statute, and it came out, and it creates obligations on both the part of the homeowner and on the part of the contractor, more on the contractor than the homeowner, but we'll get to that in a minute. So now we have this statute in place, and you have to look at the statute and see, okay, to what does this statute apply? What are the problems that they're trying to address? How did this statute kind of fit into that scheme of fixing these problems? What was it really good at preventing, and what does it need some help preventing? Um, so the statute's been changed in different places throughout the country, and different jurisdictions change these statutes. But if you run, like, for example, if you Google search a home improvement contractor statute in your state, you're very, very likely to come up with a statute there uh, that has these qualifications, has these mandates, has these recommended best practices. Many of them aren't recommended, they are mandated. But you'll get a sense of what the state is trying to accomplish, and then it's up to you to make sure that you comply with that. The one we're going to focus on today is the one from Massachusetts. But again, a lot of these statutes are modeled after each other. Um, but nonetheless, just because we're talking about the Mass statute, don't assume that your statute, if you're in a different state, is the same as the Mass statute. Again, you've got to look it up and make sure that, what do I have to do? Because these are indeed mandatory statutes, and there are penalties, and fairly significant ones, for failure to comply with them. So, first of all, I'm going to deal with the Mass statute, obviously, but you have to look and see to what projects does it apply. It doesn't apply to commercial projects, and that's a huge exception. It doesn't apply to public projects. That's a huge exception to this thing. It doesn't apply to ground up construction on residential dwellings. It only applies to existing dwellings that are owner occupied, that are comprised of at least one, but not more than four units. All right. And it only applies again to units that are for residential dwelling. All right, so there's your first four criteria of the buildings to which it applies. And now there's a different threshold of cost. There's a cost threshold. The statute doesn't apply unless your residential renovation contract reaches a certain cost threshold. That threshold in Massachusetts is an enormous sum of $1,000. So, in short, if you have a residential renovation contract and it's over $1,000, and virtually all of them are, you have just passed the two criteria. And so far, the statute is applicable and binding on you, and you have to follow it. But it doesn't end there. Now we have to we've looked at the project threshold, we've looked at the cost threshold. We also now have to look at the participants, the, the people to whom this is binding. All right? It does not apply to vocational programs in public or private schools. All right? Those people that are the students in the schools that might do residential renovation under the supervision of the schools, it doesn't apply to them. It doesn't apply to the Commonwealth of Massachusetts or its political subdivisions. It doesn't apply to those folks. And then I'm going to say something to you that's going to say, well, then it doesn't apply to anybody because the statute says it doesn't apply to a certain class of people, but then it immediately takes back and says there's an exception to that, and that exception swallows the rule. So basically, the words that they use in the statute, it doesn't apply to persons who are required by law to attain standards of competency or experience as a prerequisite to licensure. So you look at that and you say, well, okay, so that means if I had to go through a program to get licensed, it doesn't apply to me. At first blush, that would be the correct answer. However, it's not. The exception to that is licensed construction supervisors. So if you're a licensed construction supervisor, this applies to you. It might not apply to electricians and plumbers, depending on what their scope of work is, but it certainly applies to licensed construction supervisors. So if you're a licensed construction supervisor and you meet the criteria for the type of building, you meet the $1,000 threshold, the statute applies to you and you have to comply with it. It is not a discretionary compliance, it is a mandatory compliance. So, Anthony, why don't you tell us a little bit about why the statute matters? What does this thing do?
Well, real simple. If it applies to you, if Chapter 142A applies to you, you must comply. It cannot be waived. So even if you and the contractor and the homeowner have in the contract that they waive the requirements of 142A, that doesn't matter. As Drew was talking about, if this statute applies to you, then you must adhere to it and you must comply. The reason why that's important is because if you do not comply with Chapter 142A, you may be liable under the Massachusetts Consumer Protection Act, which under Chapter 93A, which would actually provide liability, and you would be liable for attorney's fees and costs and multiple damages. And as Drew has seen this play out multiple times, homeowners will actually use this as a leverage point during settlement negotiations well after the project is even done.
Yeah, so let me just touch base on it. You know, there's some confusion in the construction industry between, when a private agreement between two parties, a homeowner and a contractor, can kind of supersede another requirement that might exist out there. And there's a case in Massachusetts where the homeowner wanted something done. The contractor said it cannot be done, it violates the building code. The homeowner then said, don't worry, I'm going to waive that requirement. That requirement is there to protect me. I'm going to give you something in writing that says, don't worry about it. I'm telling you to do what I want you to do. And the contractor said, well, okay, I mean, if you're going to give me that, I'm going to do it. The contractor did it, and the contractor got in trouble. Why? Because you can't waive building codes. And likewise, you can't waive compliance with any statute, including the home improvement contractor statute. So if there's an agreement in place between the homeowner and the contractor that waives or purports to waive certain requirements of the statute, don't fall for it. It does not have any impact on the obligation to comply with this thing. And I'll give you an example. Like if I were to tell somebody, see that school zone over there with the 20-mile-an-hour speed limit? Don't worry about it. You can go as fast as you want, right? They can't rely on that and say, okay, well, Drew told me to do this, and that should be up. No, it doesn't work that way. You can't waive a statutory requirement. And the importance on this in this 142A, which is the statute, Mass General Laws, Chapter 142A, is that there's a section in this statute that says if you violate the terms of this statute, you may be liable for damages under 93A, the Consumer Protection Act, which provides costs and attorney's fees to the in this case likely homeowner that prevails, and it also gives them a gateway into multiple damages. no less than 2, no more than 3 times the actual damages incurred. So if you violate the statute, there's a chance you're going to be in violation of 93A. And if it was an intentional or willful violation of the statute, there's a chance you're going to get hit with multiple damages. That's a big, big thing that you need to avoid. And now, despite the fact that statute's been around for a very long period of time, we hear from a lot of people, gee, I didn't know that statute was out there. I had no idea. I had no idea. It's like one of those things where they don't know unless it comes back and bites them. All right. So the purpose of today's discussion is to get you out of that danger zone and to refocus you, to put you in a position where you do what the statute requires you to do and therefore protect both you and the homeowner. So, Anthony, why don't you tell people generally what they have to do to comply with this thing? What does a contractor have to do?
Well, the first thing you need to do is you need to register as a home improvement contractor. And the process is fairly straightforward. State of Massachusetts actually provides a website where you can go on and register and obtain your HIC number, your home improvement contractor number, and you pay a small or nominal filing fee. The filing fee actually depends on how many employees you have with your company, and part of that filing fee goes to a guarantee fund, which we'll actually discuss a little bit later on. And then the second important part that you must do is you must use an approved contract form, which the state of Massachusetts also provides. But as Drew will probably talk to you a little bit more about, you really want to tailor and revise it to your contract, to your project that you're working on.
Yeah, so the registration process is actually very straightforward. It's very simple. You just go online, you can fill out the information, and then they give you an HIC, a home improvement contractor registration number. So it's a very, very simple process. The more complicated process and the place where we see parties get in trouble is the use of the contract, right? The statute requires specific language in a contract. And not only does it require specific language, in some instances it requires specific font size. And in other instances it requires that certain language in the contract be bolded, right? So you have two options now. You have to use the contract if you meet all those other thresholds that I just talked about. And then you have to use this thing. So how do you use this thing? There's two ways you can do this. We've seen both, and they're both equally effective. The first is just to download a copy of it. If you hop on the state's website, chances are you're going to find this thing. We have a website to it. If you can't find it, just let us know. We'll be happy to ship the website out to you. But they have it right there. And all you do is print it out and you can use it. Everything's in the right font size. Everything's just exactly the way it needs to be for you to be in compliance with the statute. That's one way to do it. What we found, however, is that the statute misses in a bunch of other ways. It doesn't cover, for example, a lot of general conditions. If you look at the A201, the most widely used general conditions contract in the country, it's 38 pages long. The HIC contract doesn't address really these general conditions. So we find you have to breathe some stuff, incorporate some stuff into this HIC contract to make it work. But like I said, there's two ways to do this. One is just to print a copy of the contract and use it. The other is to make a homemade contract. Right? Adopt all these languages, adopt the font size, adopt the bold. Just make your own contract. That's a cost, right? It's either an internal cost. You can hire attorneys to do it, or friends and neighbors. It doesn't really matter. You can create your own contract. Just make sure that it complies with the statute, because the statute has all these requirements that need to be in there. I'm going to try not to drill down too deeply on this, but I'm going to go through some of these mandatory provisions that are required in these contracts. First of all, you need the names of the project participants. That's easy. But you also need things like your registration number, which is your HIC number, which is what Anthony just talked about, this online process where you pay a fee, you get an HIC number. You have to put that in there. You have to put your license number in there. You have to put in there a clear description of the documents, which is a great requirement to have. Contract documents, putting contract documents in a contract is probably one of the most important things you can do. And on par with that is making sure that certain things aren't in the contract as contract documents. But there's a requirement you list all the contracts. We got it. That's easy. You have to put the date of when the project starts and the date of substantial completion. Now, that is a snapshot taken at the time you sign the contract. As we all know, contracts can change. Scope can be increased, decreased, whatever. But you have to put in there, your good faith estimate of what's going to be in there. The payment side of the statute and the payment side of this mandatory contract is a little more difficult to comply with. It's actually easy to comply with, but it's hard to make reflective of the reality of the construction world. First, the contractor can't demand more than a third of a payment up front. Understood. That's easy to understand. The tricky part of the statute comes to payment. The statute anticipates that there's going to be a sum certain that's paid either on a date or when a threshold is achieved on the project, right? That's typically not how construction projects work. Construction projects work, I mean, a larger project, you build monthly often, and the monthly payment application is based on the work that was performed that month, right? If a contractor was going to put in kitchen cabinets one month, but there's a lead time on them and there's a delay in the owner selection process or the fabrication anywhere, the contractor will then typically shift and do, the basement bathroom or the fit out of the basement as they wait for the cabinets to come in. So it's hard once a project to get started to figure out on what day or at what milestone I'm going to be paid this exact amount. Nonetheless, the statute requires that. What we find is that people often, and they do this perhaps to their detriment, and they certainly do this at risk, will go back to a more traditional modeling system that says, on the 15th day of every month, we're going to be paid. And that amount's going to be dependent on how much work was performed during that period of time. The statute does not allow that, but it is, and that's a major flaw in the statute because it really doesn't reflect common sense. It doesn't reflect the reality of a construction project. If only construction projects were so adaptly timed that we knew every single month what our exact payments were going to be, it would make life very easy. That's just not an accurate reflection of the world. So the statute also has another little funky requirement. It says the law forbids demanding full payment until contract is completed to both parties' satisfaction. What happens if there's a dispute in the project and the contractor thinks I've fully performed, the homeowner's being unreasonable, and therefore I should be paid everything. I'm going to make a demand for full payment. Well, the statute doesn't allow that to happen because the project hasn't been completed to everybody's full satisfaction. So in those instances, the contractor should probably make a demand for payment, but just not say it's a final demand for payment or some other way to try to accommodate the requirement of this language in the statute. Also, you have to list all specially ordered materials. I'm perfectly fine with that. I think that's really important. In all my contracts, I usually ask that the parties put together a schedule of values and a schedule of production, just so they can kind of see things and create obligations on both sides. If I'm going to order cabinets, the owner, you have to make these approvals by this date because I've got a lead time of this and a delivery time of this to get these things to the site. So putting in a requirement in the statute, which it has, that specially ordered materials have to be listed in the contract is a good thing for this contract to have. Then the contractor also says that you have to list express warranties.
So with express warranties, you need to list them. And this is something that we suggest creating on your own. And this is something that we actually work with contractors often on in creating these warranties. Some examples of this is when you have, after the project is finished, typically there may be a 1-year period where you have finished work, where cracking may appear in drywall or floor finishing is unblemished. Things like that you come back and fix at your cost. They're not defects, but you just come back and fix them at your cost. Because if a replacement contractor were to come in and you were responsible for the repair, then you would be responsible for their costs plus whatever built-in profits they would have. So you want to have some type of mechanism in the contract that says you will come back and finish that type of work at your cost. Another thing that you want to think about is providing a mechanism in the contract that says the homeowner must give you notice of these not defects, but these imperfections or this repair work, an opportunity to come in and fix it. So you want to have that expressly provided in there and a time frame, like a 1-year period. And then something else that kind of rides along with that is homeowner maintenance obligations. Now, with residential improvement projects such as paint work, exterior paint work, you really want to have listed maintenance obligations by the homeowner because you can't come back and fix a portion of the paint on the home because then obviously you're going to have matching problems, right? Or say, for example, you have mulch beds outside around the perimeter of the home. You really want to have something, for example, the homeowner must maintain the pitch that's away from the home, not towards the home, because then you're going to have water intrusion problems you don't want to encounter. So that's something that you really want to think about. And Drew, with your experience of working with contractors and providing these warranty provisions, what other kind of things do you see pop up?
Yeah, so this is an opportunity for a contractor to really manage their risks on a project. So we often prepare what's called a limited warranty. And a limited warranty says, we'll fix these things and not necessarily defects, but we'll fix them if, a nail head pops, a little plaster pops off, you get some shrinkage cracks, etc. We'll fix these things. They aren't exactly defects, but we'll fix them. Um, but then we also include other language that says, if something comes up in this project, that you have to give the contractor notice and an opportunity to fix it before you get somebody else to come in. Now, obviously, the benefit of that to the contractor is they get a chance to fix this thing at cost if it's a problem that they own. Um, and what it also does is it prevents the homeowner from running out and getting the most expensive contractor they can to come in, fix a shrinkage crack for $10,000 when you could have done it with a little bit of spackle and a little bit of paint done in a couple of hours or less. So we usually put in this provision that says the homeowner has an obligation to let us know. Right? Let us know we messed something up. Give us a chance to come in there. We'll fix it. If we don't fix it in a certain time, then you can go hire somebody. That's an important thing. The third part that we throw in these warranties is some sort of maintenance schedule for the homeowner. Like Anthony was saying, there are things that need maintenance. Homes are a dynamic product that constantly need maintenance. They're not something that you buy and never have to look at again, no matter what you paid for it. There's always things that need to be done. And we find that a lot like with the wooden doors on the exterior, right? I mean, they need to maintain the door. They need to protect the door. They need to, periodically stain, peel, paint, poly, whatever they need to do. They need to have maintenance obligations. And drainage is a huge one, like Anthony was talking about. If they build up mulch beds that have a negative pitch towards the house, they run the risk of water infiltration. They got to pitch it the other way. They have to clean their gutters. So this limited warranty gives the contractor an opportunity to kind of let the homeowner know what their expectations are and how they can achieve those expectations. So that's really this express warranty that's required by the statute. If you have it, you have to list it. It gives the contractor a real opportunity to mitigate some of its risk and also give some working knowledge to the homeowner about what their maintenance requirements are in the home. There are some other aspects of the statute too. One is there has to be a right of cancellation. You have to have a separate sheet of paper that has, the right of cancellation. That shortly after the contract is signed, the homeowner has a period of time, I think it's 3 days, to say, "No, I've changed my mind. I'm canceling out of this project." That has to be that has to be a part of your contract. So don't miss that one. There's also an arbitration clause. That arbitration language has to be in the contract. That basically says if the homeowner wants to arbitrate through a special program, they can. If the contractor wants to arbitrate, he or she can't require the homeowner to do so. But the HIC set up this special arbitration program. It's actually a pretty good program. It can be. They assign an arbitrator who has some subject matter experience. I did one of these one time with an engineer, and the case was on elevations. And it was incredibly helpful to have our decision maker understand what elevations were and their impact on different aspects of the project. If we had a judge or a jury there, we would have spent an inordinate amount of time trying to explain what the elevation issue was. And even at the end of that, who knows whether they would have fully understood the issue. So they do have an arbitration program that's baked into this program. It's actually a pretty good one. The contract must be executed in duplicate. And from a contractor favorable standpoint, there's a clause in the contract that says that if the contractor feels financially insecure, and there's criteria and there's things that need to be massaged, so I'm just going to give this a brief oversight. But if there are things in the contract that need to, if the contractor feels financially insecure, there is a mechanism in there that under certain circumstances allows the contractor to make the homeowner put the balance of the contract in an escrow agreement, pending some sort of satisfaction that the contractor feels now financially secure. So there is a process there that helps contractors if they feel financially insecure. So let me just touch about one big thing that I see in these construction contracts, and that's this what I'll call this vacancy or an unoccupied clause. If the project is going to require that the homeowner vacate the property for a period of 30 days or 60 days, or it's going to depend on what your local laws are or what your insurance policy says. There's clauses in these contracts that say, well, we deem that property to be vacant, and therefore there's no insurance coverage on this property. Make sure that you understand what the vacancy or the unoccupied clause is in the homeowner's policy to make sure that you're not voiding coverage by not having the homeowner live there during the course of the project. This is a homeowner responsibility, but it can fall back on the contractor. If there's a fire loss, which we had in one of our projects that we were handling, there's a total fire loss. The house is gone. The insurance company disclaimed any coverage to the homeowner because of this vacancy clause, and the contractor didn't get paid. That can be a very catastrophic situation. So it's really important to kind of look at the and understand what the insurance policy says and what the insurance policy statutes are that govern these procedures to make sure that the conduct of the homeowner vacating the property for some period of time doesn't void the insurance obligations. So if you want to ask any questions, please list them in the comments, and we'll be happy to go through them. If you want to reach out to us by email or telephone call, we're certainly here to answer any questions that you may have. We'll address anything. We pride ourselves in getting back to people promptly with any sort of questions or issues that they may have on any of these things, because it's a complicated issue and the stakes are high. And it's important to understand this stuff. So please, please, please don't hesitate to reach out to us one way or another, and we'll assure you that we'll get back to you as quickly as possible. Let me just tell you what we've got coming up. So the next presentation is going to be on September 17th, and that deals with understanding key insurance provisions. It's not limited to residential renovation. It's just key insurance on construction projects. Insurance can be a little tedious to understand. It can certainly be difficult to understand. And it seems like with insurance, they give you, then they take it away, then they give it back. You've got a policy, you've got an exclusion, you've got an endorsement, you've got all this. We're going to try to take you through a little bit of that to give you a better understanding from a life perspective what your insurance things are. So that's a great program. It's important to know. And on October 21, we're going to talk about mastering the prompt pay. The prompt pay and the retainage acts in Massachusetts deal with projects that are over $3 million. So we'll talk a lot about the prompt pay, because the prompt pay has this funky payment schedule that you can get in some trouble with if you don't understand what that requires of you. So thanks to everybody for attending. We greatly appreciate you here. And again, if you have any questions, feel free to reach out to us. Thank you very much.
Thank you.